I welcome you to this court from where we left in October last year. In our last proceedings, this matter was adjourned to this date for the reason that the petitioner sought to appeal against two rulings of this court, and the petitioners sought for time to get further directions arising from those appeals in the Court of Appeal. So therefore, I would like to ask the petitioners to give us the status of those two appeals so that we are able to give the way forward.
I'm also present for the petition.
Yeah, thank you.
Lord Njomo, holding brief for Senior Counsel Paul Mwite and other advocates in the petitioner. My Lord, the petition that the matter that was before the Court of Appeal is Civil Appeal number 829 of 2024.
829.
829 of 2024. My Lord, when we appeared before the Court of Appeal judges, directions were issued that we would abandon the interim application seeking interim orders, so that we could focus on the hearing of the main appeal. The court further directed that that particular appeal would be heard before the end of the previous term, so that our expectations were that we'll get a hearing date on or about before the 18th of December last year. Unfortunately, that did not happen, and the appeal has not been heard. There have been further proceedings in that particular matter, including a ruling that was delivered yesterday as regards the filing of a supplementary record of appeal. The ruling was delivered, and the petitioners were allowed to file a supplementary record of appeal, which is deemed to be properly on record. So there is full compliance from the petitioners and the appellants in that particular matter as regards filing of their documents in the appeal, and it is ready for hearing. So that the position, my Lord, still remains that the appeal has not been heard, and we are expecting to have a hearing date for that particular main appeal, because the petitioners in this case and the appellants before the Court of Appeal have fully complied by filing all their documents before the court. So that in the circumstances, my Lords, our position for the first petitioner would be that if we can take a mention date before your Lordships for this particular matter after the appeal has been heard, because we are very optimistic that we get a hearing date for the appeal very soon. We have moved the court appropriately, and the only thing that we are waiting for the Court of Appeal is to give us a date. That will be the position of the petitioners, but I'm sure my colleague Mr. Dudley will have something to add.
Not much really, my Lord. Just to say that we can come back towards the end of this term or right at the beginning of the next term, so that we give the Court of Appeal adequate time to consider the issues before it. We are aware some other matters are coming in, but our position is that since the appeal is jurisdictional, it impacts the court's power to make any other orders in the matter. And so we can come back when the appeal has been heard and the bench has either been cleared or reconstituted. Thank you, my Lord.
Happy New Year.
Happy New Year.
I equally associate myself with the sentiments and the submissions made by my friends. That would be imperative for this court to create time to the Court of Appeal to determine that very substantive issue. Because the issue, if determined in our favor, will have far-reaching effects in the manner in which this court may or may not proceed in the future. So I would also suggest that we take favorable dates, perhaps the next time, or as proposed by my learned friend Mr. Chair Dudley, so that we can give the Court of Appeal appropriate time. In the meantime, the other proposal is that any person perhaps who has not responded or who has not amended the petition may be granted that leeway to comply as we await the outcome of the Court of Appeal. I'm most obliged.
Thank you very much. Good afternoon, my lords and my lady. I'm Noor, now before you, but not exactly Noor. 586, we filed it, it was caught up in the glitches of the 5-8 system on the 23rd of October last year. Actually, when you're dealing with these proceedings, our application, petition was caught up in the shenanigans that arose from the judicial CTS. Allow me, I'm responding to that issue.
I thought we just deal with that first on the appeal, then we can deal with 586 after that.
I thought, with respect to the professor, anybody in support or opposing in the line of petitions, when you're first or the second, third cohort, they address the judges. Then the respondents then respond. Otherwise, if we then say the first cohort addresses, it will jumble up the issue. It's my proposition.
No, I thought, my lord, the 586 is a fresh petition before you, and you're here to give directions. You haven't given directions.
Actually, that would be our next step
Yeah.
when we are through this.
So you're coming too fast.
Very well. But it implicates my petition. It does implicate. That's why I thought I should have a voice. I will wait. I'll hold my horse.
Yes, yeah.
Thank you.
The Lord. Sorry.
My Lord, sorry for coming late. I was in a murder trial. My name is Kipe Mungai. I appear for the 10. I think it should be up to 41st petitioners, 10 41st petitioners. My Lord, we were supposed to amend one of the petitions, but we've not been able to do so because there are certain information that we are seeking from the office of the Registrar of Political Parties, which we have now obtained. We would be requesting for the extension of the period for the filing of the amended petition to be extended by 21 days, partly on account that there are certain compliances with the Court of Appeal that we are trying to comply with regard to applications that have been filed. That is all allowed for the time extension of we seek an extension of 21 days. The second petition, Mr. Rigathi.
Yes.
Yeah, we agree with the position stated by Mr. Chop and Mr. Kachia. Say that in the event that the Court of Appeal delivers its ruling earlier than the next time, just in case the date is given the next time, then that decision will be brought to the attention of these courts, so that then we can reconvene earlier than that date the next time. That's all.
My Lord and my Lady, I believe on behalf of the respondent, it's also not too late to wish you a Happy New Year.
Happy New Year.
That said, my Lord, I think the directions that you gave at the beginning of these proceedings were very clear, that you wanted an update from the Court of Appeal matter, which then should inform how we progress. I would want to confine myself to that specific direction, so that then we deal with it. If there's need to deal with the matter that is before you, we can deal with it separately. Now, for the record, on behalf of the National Assembly, first, we have complied with the directions that the court had given in relation to filing of documents and responses. We have filed our responses in relation to all matters that are before you. Number two, we are opposed to any application seeking to in any way derail the proceedings that are before you. And I say that for three principal reasons. Number one, these matters were brought before you under certificates of urgency. My lords will recall the long afternoons, the long evenings that we sat because of the urgency. It is our submission that the urgency was on account of the fact that the issues in all those petitions were issues of a public interest nature. If that be the case, my lords and my lady, then it means that the public interest that subsisted then, which necessitated the urgency, subsists today. The petitioners cannot have it both ways. That when it is convenient, they say they are not ready to proceed, when on that occasion, they wanted to have you sit into the night. What is good for the goose is good for the gander. We ask that we proceed with these matters. Number two, there is no legal or factual basis that would necessitate any delay or failure to proceed with the matter or all the matters that are before you. And I say that because when we were last before you, counsels appearing for the petitioners did make an application for stay before you. They even made a subsequent application for a Madu Pepper interim injunction. My lords and my lady, if you remember, you rendered yourselves on those two applications, dismissing those applications. Similarly, the matters went to the Court of Appeal, where they made a similar application for stay. They also made an application for interim stay in the matters in the Court of Appeal. Just like you, the Court of Appeal did not find merit in their application and consequently did not grant any stay. What therefore would be the legal or factual basis for asking that we stop or we do not proceed with the matter? In our view, there's absolutely none. As earlier indicated, the respondents are very keen to have these matters heard and determined at the earliest possible opportunity. In fact, my lords and my lady, we will go a step further as to even propose that we give directions that parties file the issues in the respective petitions to pave way for an orderly determination of the matters that are before you. My lords and my lady, that would be in relation to the request that we have a temporary stay, or the request that we have a further 21 days, before we can take these matters into proceeding. It should not be lost, and this is in social media, my lords and my lady. We as advocates have been blaming the courts of delays in determination of matters. It cannot be that when it is convenient, we want to now come and orchestrate that delay and in a social media or any other platform seek to blame the court for those delays. The court must rise as to say no to that sort of invitation. In fact, I would go further as to add that this is an attempted forum shopping, which the court must decline the invite to deal with. Now, in relation to the request by Malaya Senior, Mr. Kibe Ngai for the petitioners for the 21 days, again, we are opposed to that application. We are opposed because it is our position that when a party comes before you, they always have the totality of the case that they seek to have before you. We cannot have a situation where a party would want to litigate by installments, saying, I find this in the hope that I'll get additional material before this office and that other office. My lords and my lady, we ask that that application asking for 21 days should similarly be dismissed. You are very categorical. You gave us 30 days. Nothing has happened. Nothing has been placed before you, not in the form of a letter seeking any material before any office, including the office of the registrar of political parties. My lords and my lady, this is a court of record. On what basis are you being invited to give or grant that 21 days? In fact, it is our submission that that is also an attempt at delaying this matter. I would just want to finally draw the court's attention to the attempts that have been made by our colleagues, the petitioners, in derailing this matter at each and every turn of events. We should not, on this occasion, allow them to go that direction. We ask, my lord, my lady, that you dismiss that and give directions on how we are going to proceed. I must comply.
My lady, thank you for the speaker of the Senate. My lady, my lord, we have filed our responses since October 2023 in both petitions. We were brought before this court under urgency. We have started to, I think we're now at over 20 petitions. Most importantly, my lord, this matter keeps moving. New petitions are being filed every single day. As you can see, there's a new file before you. This matter needs to be resolved urgently. That urgency that the petitioner approached this court with still exists and should apply to the respondent equally. Secondly, my lord, the matter in the Court of Appeal to date, there is no stay of this proceeding. There is no order from the Court of Appeal directing you not to seek. This matter being in the public interest, it is not just, it is not fair that it has not been resolved today. The actions that the Senate and the National Assembly took are still being challenged. We would like this resolved for once and for all as a matter of urgency. My lords, my lady, we are dismayed that the petitioners who have participated here over and over are now asking for us to wait until the end of the term for this matter to proceed. My lords, we are asking you to allow us to proceed to hearing, and we are ready to proceed at the earliest. Thank you, my lord.
It clears you, my lords, I appear for the fourth respondent, the Senate of Kenya. And Lord, I wish to add my voice to the submission from learned friend Eric Kumbo on the need to expeditiously proceed. These petitions, when filed before this court, were filed with urgency. All of them were urgent. When we concluded the applications, the intention was to expedite the hearing of the petitions, said that this court was waiting for the prosecution of the 5-2B application before the Court of Appeal. You have been told, Mr. Kanu, that the 5-2B application was abandoned, so there is no stay from the Court of Appeal. You have also been told, my lords, that there is a pending appeal and that a record of appeal has been filed before the Court of Appeal awaiting a date. That is not a stay under the Court of Appeal rules. My lord, there are two cohorts, 522 and 565. We have complied. Senate has complied. We have filed grounds of opposition on behalf of third and fourth respondents and filed relevant or necessary replying affidavits. Cohort number, the 586 that came before this court and that has been filed, my lord, by Harrison Kinyanjui, we have equally complied in that one because we had filed affidavits when the matter was before Judge Mabuye, even before this court gave direction, because we had given direction for compliance by the 10th of January. So we have complied. My lord, the way forward of these petitions as follows. My lord, this court should direct parties who have not complied, because some speak to non-compliance, within 7 days comply. The other respondents, my lord, should have a corresponding 7 days to comply. My lord, all these three petitions ought to be consolidated for purposes of hearing, and we can come back before you, my lord, within 14 to 21 days after compliance. So, my lord, maybe 21 days from today, as the court may direct, so that this petition can be heard and finalized. My lord, we cannot politicize a judicial process. We cannot come to court for purposes of adjournment every time. That parties who have filed petitions are the ones who are not ready to proceed. My lord, if the respondents, the petitioners are not willing to prosecute their petitions, let them do two things. My lord, let them withdraw those petitions or come to court on the date fixed for hearing and say they are not ready, so that you can dismiss those petitions. Otherwise, you can't keep coming here every day and the petitioners are not ready to proceed with this petition, which they said was urgent. All of that is my prayer.
Your Lordship, for record purposes, my name is Sore, voting brief for Kuyoni, for the Speaker of the National Assembly. We associate with the argument by my learned senior Kumbo, just to add that an application was made and determined as to stay of proceedings. It was dismissed. It can't therefore just be granted on an oral application by the party. Our proposal would be that we proceed with these matters and have the court frame the issues for the parties for purposes of guiding in the written submissions, so that the petitions can be consolidated, can be determined as soon as possible. I thank you.
Lord, my name is Emmanuel Peter from the Attorney General. Lord, I join my colleagues for the respondents in opposing the petition's application. Lord, my view is that once we choose to institute a public interest litigation, the proceedings don't proceed at your convenience. Lord, the principles of Article 159 and Article 2B of the Constitution are succinctly clear that matters must be heard and determined expeditiously. The petitioners have had more than 60 days to prepare their pleadings. There is no justification whatsoever for the court to extend time for them to complete their pleadings in this juncture. It is in the interest of the public and as provided for the Constitution that this matter be heard. That is all.
There's a petitioner who is appearing from, I believe,
One of the hearing was supposed to be physical.
But you can bargain.
Yes, Your Honor.
Yes, tell us your name first. Tell us your name first.
Yes, this is Teresia Wanjiru Kimoto from Test Moto and Company. The second petitioner. Your Honor, if I'm allowed to say something, I don't know, everybody seems to ignore my presence, but I'm here online.
We have acknowledged you and we can see you can proceed.
Yes, I wish to say that for the interest of justice, I think the petitioners can be allowed just one more chance to amend their petition. However, we should also not take long. We need these issues determined. Though we would also say that once the now current Deputy President Kindiki Kithure was sworn in, I think that's when the agency ceased to exist. The public has moved on, but nevertheless, we are still in court and we need to be heard. Therefore, we are urging this court, if it's going to grant the petitioners one last chance, then let it be the last, so that we also move on to the real issues. That's all.
Thank you.
My lords and my lady, Nishuki appear for the interested party, the Law Society. Mine is simply an issue of housekeeping. While the court did issue the directions on amendments and filing of responses, the same have not been served on the other parties. And while my Lord Justice Murima had indicated that parties could check for these pleadings on the e-filing portal, this is made difficult given the number of petitions and the far-ranging jurisdictions. We have petitions from Kerugoya and new petitions from Milimani. Maybe a direction can issue that the pleadings are filed within the lead files, that is 522 and E565, so that all parties can access these pleadings.
I think that direction was made. We made that direction that pleadings be filed within those two files.
That is fine, my lord. I think that should be reinstated because we have not seen, I think I've seen Mr. Kumo's response, but for the other parties who've done their responses, I'm not seeing.
But, my lord, if I could very kindly just remind my learned good friend of Justice Murima's dedication that in this advent of IT, once the documents are in the portal, really, we all have access to the portal. Would that not be another reason to just ask for a delay?
My lord, I was not seeking. It was not a delay tactic as my learned senior would like to contend.
It was an inquiry.
It was just an inquiry where they are finding this.
All right, thank you.
Yes.
If I could be heard very briefly in rejoinder, we concede that Article 159 2B requires matters to be heard without delay. That's a constitutional principle. But even before I say what I say, does the court consider that this matter has delayed? Because this is a constitutional division, and the judges of this division can take judicial notice of the docket and how far they've gone in hearing the matters that are before you. But turning to constitutional argument, it's also a principle of the Constitution in 159 2D, I believe, my lord, that the purposes and the principles of the Constitution must be protected and promoted in the exercise of judicial authority. The point I'm making, my lord, is that there's a constitutional principle known as precedent or stare decisis. In a case that Professor Ojenda argued, the Kidero versus Waititu case, my lord, the Supreme Court asserted that precedent or stare decisis is a constitutional principle. So when you're being told that look at 159 2A, you must also look at 159 2D. Why is that important? My lord, we have a pending appeal at the Court of Appeal, challenging the standing of this bench to exercise judicial authority over this matter. yet you're being asked to proceed with this matter despite that pending appeal. That has happened before, Lord. It happened in the Nyamawi case concerning Wiva. My Lord Justice Ogola was a judge in the Nyamawi case, Juma Nyamawi. The Law Society of Kenya was the Attorney General. When the matter went to the Supreme Court was not happy. It was dismayed that the High Court, despite being aware of pending proceedings before the Supreme Court, had gone on to do exactly what my learned colleagues are urging the court to do. My Lord, to protect the Constitution in this case, you are obligated. My learned friend Mr. Gumbo suggested there's no factual or legal reason for you not to proceed. There are two Supreme Court presidents, the ones you cited to you. They command, they obligate you, my Lord, to hold your horses until the Court of Appeal gets the appeal out of the way. We've done everything we can as counsel to expedite the hearing at the Court of Appeal. We believe that the hearing is imminent, and when we come back to you at the end of this term, or at the beginning of the next term, or maybe if you can allow the matter to be mentioned, if the Court of Appeal hears and decides the matter before the date you fix, we will be ready to proceed. My Lord, no one is keener than the petitioner, former Deputy President, to have this matter. It's his case. It doesn't serve him to have it delayed here, but it must be heard consistent with the law. What the law now says is that we wait for the Court of Appeal. Thank you,
My Lord, just to add on what my fellow friend has indicated, is that while we appreciate public interest in the current proceedings, it's equally important for us to appreciate that the matter that is pending before the Court of Appeal equally generates serious public interest. Public interest stems all the way from this court or the hierarchy. It is in the interest of the members of the public for the Court of Appeal to determine that very fundamental question of how this bench was constituted. Number two, my lords, on the issue, the desire to sit, if invited to do so by the respondent, will be tantamount to ousting the jurisdiction of the Court of Appeal. You will simply be closing your eyes to the fact that a court, a superior court, is seized of a very fundamental question that ought to be determined before these proceedings are completely exhausted before you. My lords, my lady, it then means that if you're invited to hold in favor of the respondent's submissions, you'll be rendering the appeal nugatory and an academic exercise. That is to mean, my ladies, my lords, that the court is being invited to be oblivious of the fact that there is a fundamental question that has not been answered by a superior court. There has never been delay in these proceedings, and the public interest has not dissipated with respect to these current proceedings. All what we are asking is the court be reasonable enough to create time for the Court of Appeal to adjudicate over the matter that is pending before it. It's a fundamental constitutional question that is being raised that will inform the manner in which future benches of judges will be empaneled and who will empanel them. So that case will impact the posterity of how the bench will be constituted. Finally, my lords, I have not had any respondent indicating the prejudice that they are going to suffer if you are to allow our application and if you are to agree with our proposition. The respondents are in office, they are enjoying the trappings of powers. It is our client who is suffering. And therefore, if there is anyone who is keen on prosecuting this petition, it's a petition. We are actually looking for the day when this court will uphold the petition in our favor and see how Mr. Professor Ojenda's clients will react to that judgment. We are most of it.
Your Lordship, I just want to make it simple and very easy for the court. The petitioners are not saying that they are not ready and willing to prosecute the petitions. All what they are saying, Your Lordship, is just one question which we would like the Court of Appeal to determine, and if it goes in the negative, we'll come back before you. If it goes, if the court says yes, there was the bench is not properly constituted, then you down the tools. So the right question to us is, what would happen to judicial time spent in the event that we proceed with this hearing? Then the Court of Appeal says the matter ought not to have proceeded before you in the first place. So, as Mr. Jomo stated, all documents are before the Court of Appeal. So let us give them some little bit of time. Let us not even go to the next time. Let us just give them some reasonable time to determine that position. And just one thing, the applications for stay of proceeding before the Court of Appeal were never dismissed. It is actually the petitioners, now the appellants in the Court of Appeal, who said, let us not take too much time arguing these interlocutory applications. Let us abandon them. Let us hear the appeal with expedition. So basically, the petitioners, the appellants, are very busy in the Court of Appeal prosecuting the people. So just give them some little bit of time and you come back before you to prosecute the petitions. Thank you.
Thank you.
Just a brief response to the objection to our request for 21 days. But the court will note that constitutional petitions number 570 was filed, I believe, on the 18th of October 2024. Directions, I believe, in this matter are given either first day of November 2024. My Lord, that is barely a period of 14 days, and evident that the Butuka rules, for purposes of close of pleadings, will require about 30 days. Parliament ordinarily takes forever. Its advocates are here, even to give the copies of the Hansard. My Lord, we have requested for 21 days. We have collected a lot of information that is very relevant for purposes of the function of this honorable court. And we had a vacation in between and a lot of additional work at the Court of Appeal. So our request is in good faith and is very reasonable. We ask for 21 days much as we welcome Mr. Ojenda's concessions that we can get 7 days. 7 days in view of the workload that we have before us arising from this matter would be insufficient. We ask you to uphold our request for 21 days. Most obliged.
We will have parties raise any other issue before we adjourn to consider the application for further time. So we'll hear Mr. Pinyanji and any other matter.
I think my learned friend should go first because I think he's in the existing proceedings. Are you in the loop? Oh, thank you. My lord, my lady, contrary to the position taken by my learned friend, Ms. Tanji, and Professor Agenda, we haven't filed a new petition. Our petition was filed on the 23rd of October.
What is the date?
Sorry, the date of the petition?
Yes.
It's dated the 23rd of
Petition number?
586.
586.
E586 of 2024.
Yes.
My lord, my lady, that petition was filed on the 23rd of October. Mysteriously, the e-filing system developed glitches. When we went to establish from the registry what exactly, and I'm trying to answer Ms. Tanji's contention, and Professor Agenda's contention, that a new petition has popped up, being filed to settle the existing petition, which is not the case. When we went to the registry to find out exactly what is the position at the close of business on the 23rd, we were told that on the 24th we may get feedback. Then we were informed that somehow the file had been allocated to the Honorable Mr. Justice Mugambi for the determination of our certificate of urgency. Why? Because we were supposed to be coming before you contemporaneous with the petitions before you. That was our request. Somehow, the file was then supposed to be taken again from the CTS indication, and I got a screenshot for that. I'm trying to answer this time to this abuser of the proposition that we have filed a petition. He was then relocated mysteriously to the Honorable Ms. Justice Muta. Somehow, again, it was taken away from him to the Honorable Ms. Justice Momui. Now, when he finally did find space before the Honorable Justice Momui, he did certify it as urgent on the 25th of October. And we were allocated the 1st of November for the hearing. We duly served, complied. And this was before the swearing in of the Honorable Professor Kithure Kindiki. The day that we were to be heard was declared a public national holiday. So this proceeding did not go on. This proceeding was supposed to be before you as well as the other petitions. Now, when we then appeared before his lordship on the 15th, we informed him that we had amended the petition. So we had filed a motion to amend the petition and the original motion because the subject respondent had been sworn in, quote unquote, as the deputy president. Now, your lordships, we had asked, and I'm trying to also address contemporaneously my learned friend's plea for the stay proceedings, so that your lordships can consider that, because it will implicate your decision ultimately. We had asked that her ladyship be pleased to order an expanded bench because we were informed of your existence in this particular bench and what had happened, and therefore the matter was to be referred to her ladyship. To cut the whole proceedings short, we abandoned the interlocutory application. His lordship, the Honorable Justice Momuye, then certified as worthy of a bench, referred to the Honorable Chief Justice on the 16th of January this year. Now, unknown to us, on the 17th of January, the Honorable Chief Justice said that she has constituted a bench of your lordships, Mali. In other words, she was affirming the decision that you continue hearing this petition. Now, I had requested her ladyship to consider an expanded bench to add to your lordships, my lady, because of the public interest and the grave issues raised. Our petition is not new, as you will then see, and Ms. Tanji has not even said that it's a new petition. Why do I say that? Your lordships, my lady, I'm of the view that the Court of Appeal, if it was seized of the ramifications, the true extent, scope, and application of Article 159 2B, which my learned friend Mr. Peter has alluded to, it would have heard that application for stay and main appeal. It is not. It's not minded to listen to that for whatever reason. We have seen other petitions, other appeals before the Court of Appeal being given time. They are heard on an urgent basis. The recent most being the Social Health Insurance Fund appeal. A record 7 days. No. I'm not casting any aspersions. I'm trying to show the Court of Appeal could have heard these appeals if it was managed to do so. No, let me finish.
We are not going to address the issues from the Court of Appeal. The Court of Appeal will not be subject of discussion in this court.
Yes, but it was late. It was late here, with respect.
No,
I'm trying to say
we cannot talk about the Court of Appeal in that manner in this court.
Just for the record, we are quite happy with the progress of the Court of Appeal. And that's why we're asking you that we come back at the end of this term.
very well. Let me
confirm whether his client is a party in the Court of Appeal.
You can see we were railroaded off the joining. So my client is not party to the Court of Appeal. I'm just answering my other friend. To him, probably it's in jest to say so. But the larger public there is concerned.
Mr. Ching has clarified that they have no problem with the Court of Appeal.
Very well. Now, the point that I'm making, my lords and my lady, is that even if we were to look at Order 42, Rule 6 of Rule 1 of the Procedure Rules, to draw from it, no appeal or second appeal will apply as a stay of execution or proceedings. My client is concerned that we will delay this hearing, and in the public interest, we will lose the constitutional issues that are raised. I would rather you heard this petition one way or the other decided. I would rather your lordships, whichever position you will take, hear it and determine. We will have saved time so that if you dismiss these petitions, we move on to the Court of Appeal within the shortest period of time possible. The nation requires an answer to these constitutional issues raised hearing. And my answer to these request for time by my learned friend, with tremendous respect, I will differ with him. My client would like an expedited hearing of his petition. If it were possible, as a standalone petition, E586 proceeds, I can be ready to proceed and prosecute it tomorrow. For the record, apart from Mr. Bita and my learned friend, Professor Tom Magenta, nobody else has cared to respond to the issues we have raised. And one of the issues that we have raised is so weighty. So as I close, my lord, so that you can examine this issue, is that we have said that an unconstitutional act is not a law. It confers no rights. It imposes no duties. It affords no protection, even to Professor Kithure Kindiki. It creates no office. It is, in legal contemplation, as inoperative as though it had never been. If that will be your finding, ultimately, and we hope so, my lords, my lady, it will not necessitate an appeal. But if you should disagree with us, we will still invoke that position in the Court of Appeal. So for us, in conclusion, we are better off expediting the trial before you, seeing that the application for recusal was denied, seeing that the application for stay proceedings was denied, seeing that the Court of Appeal has, as it were, not dealt with the main appeal in spite of the stay of proceedings being given. My lords, my ladies, an order for stay of proceedings is very drastic. It implicates Article 48 rights, Article 25C rights. So for us, who are not privy to that particular arrangement earlier on, we beg to differ, my learned friends, and we would request, A, anybody else who wishes to oppose our petition, we are very happy to read their opposition. They will not be able to rebut the bundle of material that we have right here. And as they have it so far, those who have, they haven't. And we serve them. And my Lord, you will in the end find that it is far better off we get this over and with as a nation, so that we know if the process is invoked in the removal of His Excellency Deputy President Honorable Gachagua, were constitutional or not. It does not behoove us as a people, guided by the principle of rule of law, to keep this hanging over our heads like a Damoclean sword. And for the first time, I would agree with Professor Ojenda's proposition that we move on. You give timelines. Like I said, I rehashed, without wishing to vex your lordship, we can have a standalone petition, 5 to 6. We'll be happy to move tomorrow.
Oh, you see.
My Lord, subject is I appear for the 9th petitioner in the second cohort. You gave directions that whoever who has something to say will return to do the ruling to say it now. My Lord, we stand to support the position taken by my colleagues, petitioners, except for Harrison Kinyanjui, that you accord us time. And in so complied with the filing of pleadings and also await the ruling as shall be done by the Court of Appeal and directions that will be done there, so that we don't rush this. In as much as we came under certificate of urgency, we don't rush it for purposes of just doing it. My Lord, the ramifications of us proceeding the way we are is that the pleadings or parties have not really complied, and the court is not given or has no full material of what is going to decide on, so that we can be able to now onboard everybody and move on as a team. We will be more than glad to have your directions, so that you give latitude to the petitioners to put their house in order, and they'll have an opportunity to respond to it, so that we move on while not getting disgruntled that we are not given an opportunity to ventilate our case in the best way that we know and in the best interest of our clients. Thank you.
My Lord, my lady, my name is Homo. My Lord, I appear in petition 576 of 2024, where I represent Mr. Stephen Ouster. 576.
My Lord, may I just say that? My Lord, my understanding was that you would respond to Mr. Kinyanjui's petition, which is a standalone third court on its own, and that we were done with court 1 and 2. And now we are going back.
No, we have finished the issue of whether or not the parties will be given more time. We are dealing with the new petitions which were brought after the event.
After 5, because the 586 is the one that we know, but now they're going back on the others.
There were a number of files which came after the closed. Okay. Yeah, so in fact, if there's anybody here with a file which came after we had adjourned last time, you can raise it up.
Yes, my Lord. Thank you. With your permission. Yes, my Lord, ours was to seek direction. 576 of 2024. My Lord, my name is Komo. I represent the second petitioner, Mr. Stephen Ouster. My Lord, ours was to seek direction on consolidation of the matter. This is the first time that this particular file is appearing before you, my Lord. It was before Justice Mamuye, and it was forwarded to the Honorable Chief Justice for impanelment, and that's how it found its way before you, my Lord. So ours is just to find direction, to get direction so that we can know where we stand. Thank you.
If it may please you, my lady and my lords, my name is Otieno, in petition number 567 of 2024. 567 of 2024. I am the petitioner.
It came after the events.
Yes, it was filed on the 18th of October. However, it was not mentioned before you, and the bench was only empaneled, I believe, in November last year.
The same bench?
Yes, the same bench, which means that this is the first time that this petition is being mentioned or should come before you.
Having said that, my lords, I wish to submit that my petition needs amendment, just like some of the petitions here which have not, some of the petitioners here who have not been able to amend theirs. And I will be seeking time for me to be able to amend the petition and serve it upon the respondents. I have also not been served with any response to that petition. I've had some of my colleagues mentioning that they have responded to some petitions. Mine has not been responded to.
Have you served it yourself?
It was served. Yes, it was served. That petition was filed together with an application. However, when the office of the deputy president became, was occupied, when the new deputy president took over, I thought that it had been overtaken by events, and therefore I withdrew that application. So for me today, I just seek time to be able to amend that petition and serve it upon the other parties. On the question of urgency, because that affects the petitions which are being mentioned before you for the first time, my lady and my lords. Should you decide that we should proceed with this matter, it will prejudice some of us who are now coming before you for the first time. We are entitled to equal protection of the law, and we request that we should not proceed until we have been given time to comply as well. Thank you.
My lords and my lady, Sctnews, Momani, I do appear in petition number E598 of 2024. Your Honor, this petition was started as Mombasa petition the file that is currently before court is E598 of 2024. Formerly E06 Mombasa E067 of 2024. Your Honor, I will appreciate the sentiments that have been submitted by my learned senior, Mr. Kinyanjui, and the frustration that we face as petitioners, because some of us filed our petitions early and we were never able to participate. And this petition is coming up today. We failed to participate in the application, but we come in full force and we are willing to participate in this petition. On our part, we've already amended the matter when it was before Lady Justice Olga Sewe, before it was transferred. Lady Justice Olga Sewe gave parties leave to amend their petitions. We amended our petitions, which is dated the 23rd of October 2024, and we've served all our pleadings on all parties. I believe the parties that I've seen that have entered appearance is Mr. Gumbo, Pamo Gumbo, and associates on behalf of the National Assembly, and Moni Mukele advocates on behalf of the Senate. So as a petitioner, we are ready to proceed, but maybe I will not agitate what other advocates have. I'll not repeat what other advocates have said before this group, but I'll add that all parties, especially the petitioners, be given time to amend their pleadings so that when we go to hearing, all of us are fully ready to proceed. Thank you.
Is there any public application in this petition?
The application that was in these petitions raised similar matters as those that have already been handled. So it is overtaken by event. So for us, on our part, we just proceed to the full petition.
But we need to make an order on both.
It's okay. Okay, or otherwise, when we appeared before on the 7th, we had already said that the matters are live before this stage.
Can we mark them as withdrawn?
We can mark them as withdrawn, yes. Maybe the informed which cohort we are joining, is it the second cohort?
My Lord, before Mr. Gumbo addresses you, I forgot to tell the court that we serve the physical copy. Physical. Other than e-filing, we serve every one of the respondents and issues with a physical, any stamp. It's in the affidavit of service. So that, my Lord, when you're making directions, we ought not to be then burdened with additional sites.
Mr. Sctnews, you can to confirm whether there are any pending applications in your application.
No, my Lord. No.
Mr. Pungu?
Yes, we had one, my lord, already, but we can mark them as withdrawn, overtaken by things.
Mr. Gumbo, which issue do you want to address?
Well, I think in the interest of time, let me address the issues in a consolidated sense for all of them, because my response is the same for all the issues.
And only you will speak on behalf of the respondents.
Maybe two people. And there's a risk of the possibility that maybe there could be a respondent who has a different position. But I wanted to first state that on behalf of the National Assembly, we have filed our responses in all petitions, including 567, 586, and we have equally served them. Now, that notwithstanding, my lords and my ladies, I think it is playing out that there is a possibility that there could be other petitions that may be finding their way to this court. If we say that we want to wait for all those petitions, it is unlikely that we will be able to take off this matter. My first proposal on behalf of the National Assembly is that the court considers consolidating all these petitions, because the issues are now, where the reason why we had cohort 1, cohort 2, and the subsequent one was largely on account of the issue of conservatory orders. Would it be possible that we consolidate these matters, maybe give any party who has not responded 7 days to file whatever they want to file? If somebody wants to amend their petition, is it possible that we agree that within those 7 days they should have filed and served, and everybody responds? That, my lord and my lady, would help us move forward. Number two, in relation to the repeated plea on the question of the proceedings before the Court of Appeal, I want to just very simply state that we cannot sit before you in the hope that there is a stay order that is coming. The court must proceed. On the day when the Court of Appeal, or indeed any other court, makes a determination, stay the proceedings, the simple thing that my colleagues know is that you will down the tools. We will not have wasted judicial time. If we start to wait until maybe another 2 months, 3 months, 6 months, we'll be saying, if we had moved, we would have saved the time that we would have had in January, February, and March before each of your diaries get full. Lastly, I want to just point out, and first in agreement with Mr. Kinejui, that he appreciates that the urgency in this matter continues. Can we agree that even as the petitioners themselves, they seem to be taking diametrically opposed positions as to whether we should proceed or not? We want to urge you that we go with the position proposed by Mr. Kinejui, supported by Mr. Momanyi, that we should proceed with this matter, so that the public interest concerns in this matter are determined. And the reason why that is important is because some of the issues would give guidance to similar processes in other fora. It could be in a county fora or any other fora. That's why this public interest question must be determined in that sense. And that's why I even propose that you could even add that we, each of us, in addition to filing whatever we want to file, also frame our issues and collapse them into what, because there's a serious correlation between all these petitions. If we say we rely on each individual person's statement of issues, we may end up having a repetition of all those things. Is it possible that we present them to you, then you could consolidate the issue